My response is not the most important part. It's the second important part. The most important part is the lunch reception that will follow. Chief Justice Lucas P. Bersamin, Senior Associate Justice Antonio T. Carpia, honorable colleagues and brethren in this court, may it please the court. I thank everybody. I thank God, first of all, for everything. Thank you, Lord, I reached the age of 70. I hope I reach the age of 75 so that I can enjoy my pension from the court. And if God is extra benevolent, I hope I reach the age of 90 so that I could attend the retirement ceremonies of Justice Hernando, Justice Marvick, and Justice Ben Kagiwa. Thank you all for sharing this event with me and my family. Your Honors, thank you. As a young lawyer, I dreamt of making a difference in the world, but I never imagined that I would someday be blessed with the honor of becoming a member of this esteemed institution. I have been a lawyer for 47 years, and I spent half of those years in the service of the judiciary. I was appointed as an RTC judge in 1994, as a Court of Appeals justice in 2003, and as an Associate Justice of the Supreme Court in 2017. But as I rose through the judicial ranks, I realized that the higher the office I occupied, the more humbling the job became. Associate Justice of the Supreme Court is no doubt a position that brings both prestige and distinction. However, as current and retired justices of the court can attest to, beyond the lofty title lies an incredible amount of responsibility which cannot but ground and humble any member of the court. With the sheer volume of cases to be resolved, a justice job involves unremitting hours of work. Inside their chambers, justices are scarcely different from lawyers preparing for a case. But what distinguishes our job as magistrates of the highest court from legal advocates is the pressure, the responsibility to be right as the final arbiter of legal controversies and as the last bulwark of justice. Some may think that it is easy to be right because one needs only to follow one's innate sense of right and wrong or one's sense of logic. But a justice of the court is not supposed to be ruled by his or her convictions or beliefs. The court must decide based on what the law is. The law, however, is not always as clear as the light of day. It is not always straightforward or complete. And as a revered tax law professor also once said, the law is not always logical. The court's decision to apply and interpret the law as we think it is intended to be appreciated or enforced may not always sit well with members of the public. But it is not the court's mandate to be popular. Justices of the court are not called upon to please. Our authority is tied to and limited by the law we are tasked to construe. And if, as unraveled, the law leads us to decide a certain way, it would be a breach of our sworn duty to decide differently and simply succumb to pressure from particular sectors of the society. With the advent of social media, actions of the Supreme Court now more than ever have become increasingly open to public scrutiny. Emboldened perhaps by the anonymity afforded by such platform, people have become unhindered in voicing their opinions that sometimes border on contempt. What saddens me is that oftentimes these opinions are given evidently without those persons having actually read the court's decisions. Our institution is not one to engage in public debate to defend and justify its actions. But I take comfort in the fact that the Supreme Court is one of the most transparent offices in government. Its conclusions and dispositions are not unreasoned, unjustified, or unexplained. By constitutional mandate, the basis of the court's action, in fact, law and jurisprudence are set out in its decisions, which are released and made accessible to the public. Our decisions indeed serves as a rebuttal to any unfair criticism directed at the court. In this day and age, when everyone seems to have an opinion, and when great institutions are so recklessly maligned and ridiculed, I am confident that the Supreme Court will remain strong, because the best antidote to falsehood and fallacy are truth and reason, which the court has never denied the public. In the short but substantial period I spent as a member of the court, I learned firsthand of the processes and projects aimed at unclogging court dockets and promptly resolving cases. It is towards these same ends that I respectfully impart this message to my brethren in the court. Given the sheer volume of cases which the court must attend to, the court may consider doing away with prolonged deliberations, since the objective is not to come up with a perfect decision, but to arrive at a correct adjudication, and to do so as promptly as possible. Indeed, the parties are not so much interested in the language of the decision as they are in the relief they may be entitled to. Ultimately, what the litigants expect is not a masterpiece of a decision, but the prompt settlement of their controversies. As Voltaire once said, "Don't let the perfect be the enemy of the good." The court has been cognizant of the dangers of judicial activism and has been vigilant in avoiding adjudication that results in judicial legislation. I trust that the court will continue along this path, as we are not tasked to decree rightful conduct on the part of litigants or to craft guidelines to direct their future conduct. We are tasked merely to resolve issues presented to us. Indeed, we should not engage in judicial legislation if we do not want our legislators deciding cases. My experience serving in the court also underscored for me the important roles of lawyers, judges, the IBP, the JBC, the PhilJA, and the media in the effective administration of justice and in preserving the dignity of the judiciary as an institution. It compels me, therefore, to urge lawyers to be candid, forthright, and honest. When confronted with cases which are clearly unmeritorious, they should not give false hopes to their clients and knowingly perpetuate the frivolity of their cause. If their cases can be settled under fair and reasonable terms, lawyers should help them forge a settlement. By this, they also help in the decongestion of court dockets. I am reminded of the sage advice given by the iconic Abraham Lincoln, himself a lawyer. Lincoln said, "Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will be business enough." I like how Lincoln referred to lawyers as peacemakers. Perhaps it is this role that lawyers today should pay more attention to and strive to fulfill. I also ask judges to recognize that they are dispensers of justice, that they are foremost tasked to settle disputes, and that they should promote peace and harmony between the parties and in the community. Their job is not to enrich jurisprudence. Although they contribute to legal education by their decisions, courts exist primarily to adjudicate. People go to them because they have problems they want the courts to solve. Their mandate is to address that problem and to settle the controversy. To approach cases primarily as conflicts to be resolved and only incidentally as an opportunity to explain the law will move judges to act more swiftly and with greater regard for the personal impact their decisions will have on litigants and the community. This past year has been particularly challenging for the court, with certain sectors of the legal community fervidly expressing their criticisms and even their discontent of particular actions of the court, some with overtones of impropriety and breach of judicial duty. It has been both disheartening and alarming to learn of these denigrations, which at the end of the day erode the public's confidence to the ability of this institution to administer justice. Lawyers, as judges, legal practitioners, or members of the academe, are all officers of the court. The IBP, as the official organization of all Philippine lawyers, must be the first to acknowledge and advocate this solemn duty. In this regard, I urge the IBP not to forget that it is an organization that should promote the best interest of lawyers and the courts. They are not advocates or propagandists of causes, but keepers of the public faith in the court's capacity to render just decisions. They may rightfully express their concerns, but should refrain from publicly criticizing decisions, more so from signing and publishing manifestos. Indeed, they should be the first to promote obedience to and respect for the courts. Furthermore, as they speak for the legal community, they must be careful to reflect and represent only what the IBP membership in its entirety, or at least by its majority, intends to make known or advocate for. Lawyers of all professionals should know the power of words. We read, analyze, speak, and write them for a living. As the author Robin Sharma said, words can inspire and words can destroy. So choose your words well. It is therefore imperative for the IBP, nay, all lawyers, to use the power of language and argumentation in such manner that preserves the dignity of the court and what this institution represents. No less than Canon 11 of the Code of Professional Responsibility demands that lawyers shall observe and maintain the respect due to the courts and to judicial officers, and should insist on similar conduct by others. On the Judicial and Bar Council falls the heavy responsibility of ensuring that judicial posts are filled with individuals whose credentials, temperament, and capacity to serve will contribute to the growth of the judiciary and maintain its long-held ideals of fairness and justice. In this light, I entreat the JBC to remain circumspect in this election of judges. It is my humble view that intellectual prowess should not be the foremost criterion or the main consideration in such selection. You do not just appoint a summa cum laude or a brilliant trial lawyer or an excellent academician. More than a phenomenal grasp of the law, sound judicial temperament and effective leadership are the hallmarks of a good magistrate. Knowledge, indeed, can be acquired. Judges can be further educated. They can rule based on thorough legal research and be assisted by knowledgeable law clerks. Judicial temperament and effective leadership, on the other hand, are largely product of experience and influenced by a judicial candidate's personality and disposition. Excuse me. According to Socrates, 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. It will be noted that Socrates used the term wisdom, which does not mean intelligence, but discernment and good sense. Clearly, in the choice of magistrates, greater emphasis must be given on the candidate's ability to understand and deal with people, to handle stress and criticism, to listen and communicate effectively, and to show patience, courtesy, and tact. We certainly do not want the spectacle of a judge going ballistic over a decision of this court, or behaving like a petulant child when she does not get a desired courtroom. Composure is a mark of stability. Thus, we cannot have judges who are likely to exhibit what has been described as irritable judge syndrome. We cannot tolerate arrogance and self-importance among members of the bench. Judgeship does not confer privilege, but responsibility. Judges are not gods, but public servants. Judges must be willing to listen to views opposite their own and accept the possibility that they are wrong. They must be able to honor the hierarchy of courts and respect any reversal of their judgment with humility and grace. As the Scottish philosopher David Hume acutely observed, when men are most sure and arrogant, they are commonly most mistaken. Given the importance of judicial temperament in the selection of judges, I urge the JBC to ensure that a comprehensive and reliable psychological examination be made of judicial candidates to enable the council to effectively and accurately gauge their ability to handle the pressure, nuances, and demands of the judicial office they are applying for. In the same vein, I ask the Philippine Judicial Academy, who has already made substantial contributions to the continuing education and training of judges and judicial candidates, to consider giving a special course or particular seminar that will further enhance the judicial temperament and leadership skills of judges, including a course on how to handle the intricacies of judgeship in the age of social media. Events of recent memory have underscored the distinct power of the media to shape public opinion about the Supreme Court. Freedom of expression is truly one of the treasured liberties of every democratic society. I feel compelled, however, to implore the media not to be too harsh on the courts and to take into account the volume of cases they must attend to and the hours necessary to review every case, to study every applicable law and jurisprudence, to weigh the evidence, and to write the decision. I encourage those who report on and publish opinions on the court's decision to read the ponencia in its entirety. I entreat them to set aside any prejudice or preconceived notions and appreciate the decision exactly for what it says and not for how it contradicts their own views. Only with such open-mindedness can they really be free to form a rational and fair opinion of the court's judgment. I further ask the public to have faith in the Supreme Court. We have instituted processes and programs that ensure the transparency of our actions, the accountability of our officers in the speedy resolution of cases. We hold sacred the trust you have reposed in us as the final arbiter of legal controversies. And we assure you that every day, in every case, we endeavor to earn and maintain that trust. The challenge of resolving novel and complex legal issues becomes easier to bear when shared with colleagues whom I had the distinct privilege of working with. I am humbled by their brilliance and quiet fortitude, and I am inspired by their fastidious commitment to the rule of law and their unmitigated desire to serve. The respect and openness they have demonstrated during our meetings and deliberations are a reflection of democratic values that will continue to ensure the sound and just resolution of cases brought before the court. So to my colleagues, my court family, thank you for your guidance when I joined the court, for your support as I took on monumental tasks, and for your example of excellence, equanimity, and grace. I also wish to thank the Clerk of Court, the division offices, which my office had the opportunity to work with. We are grateful for your help, especially when we were just starting to work in the court, and we value the support you gave us as we navigated the court's unique system and processes. I furthermore wish to express my appreciation for my entire staff, whose diligence, enthusiasm, and commitment far exceeded my expectations. They came out with 4 books in a span of 6 months. Okay. Your support has been invaluable, and it was a joy to see the law from the perspective of your young mind. And on a personal note, I would like to express my profound gratitude to my family, especially my wife, Cynthia. Cynthia carried me literally and figuratively through the years. That's why she walks with a cane now. She only attended twice the JBC interview. In 2003, when she attended the JBC interview, I was shortlisted and I was appointed to the Court of Appeals. In 2016, she also attended for the second time the JBC interview, and I was shortlisted and appointed to the Supreme Court in 2017. But in previous JBC interviews, which she did not attend, I was either shortlisted but not appointed, or not shortlisted at all. When justices retire, they are often asked about their legacy. One's valued legacy, however, is not something a person has power or control over. It is something personal to each and every individual who has ever met, read of, or learned from another. As an inspirational author once said, legacy is etched into the minds of others and stories they share about you. The most, therefore, I can do is to hope and pray that my service in the judiciary will be regarded with kindness and respect, that my opinions will continue to instruct, if not inspire, discourse, and that people will remember me as a magistrate who decided cases not based on personalities or public clamor, but according to the rule of law. In closing, allow me to borrow the words of Henry David Thoreau when he said, "I am grateful for what I am. I am grateful for what I have. My thanksgiving is perpetual." Thank you and good day.